Major breaking news out of the state of Illinois. We have another Illinois state judge. This time, Judge Scott Webb in White County, Illinois, has declared that the state's so-called assault weapon ban and so-called ban on so-called large capacity magazines is unconstitutional under the Equal Protection Clause of the Illinois State Constitution. Stay tuned. We're going to break this down when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms and help us hit 100,000 subscribers. Okay, major breaking news. Another huge win today. Huge win for the Second Amendment for our friends in the state of Illinois. Specifically in the case of Darren Bailey et al. Versus Pritzker, the Governor Pritzker out there. We have another judge, in this case, Judge Scott Webb of White County, Illinois, has come out and said that indeed the recently enacted so-called assault weapon ban, that among other things, according to Judge Webb, bans the restriction and sale of what is defined as assault weapons, which, as you know, is just really semi-automatic rifles, and also so-called large capacity magazines, which are really just standard capacity magazines that hold more than 10 rounds, right? So anyway, the bottom line is that Judge Webb has declared that this law violates the state of Illinois' Constitution, specifically the Equal Protection Clause. Now, I flagged this in a different video that I released about an appellate decision also upholding an injunction against the law, at least with respect to the 800 such odd plaintiffs in that particular case, saying that under the Illinois Equal Protection Clause, it incorporates by reference the fundamental right to keep and bear arms, and the appellate court in Illinois upheld an injunction of that law as to the plaintiffs in that case. Now here, Judge Webb has basically said that he agreed with that decision and said that the Equal Protection Clause here was violated because the right to keep and bear arms in the state of Illinois is indeed a fundamental right. And when it's a fundamental right and there's an attempt to restrict it or distinguish between Illinois residents as to who's allowed to exercise it and who's not allowed to exercise it, it potentially violates the Equal Protection Clause. And in this case, it did violate the Equal Protection Clause for reasons I'll get to in 1 second. Now, I should mention that one of the critical arguments made by the plaintiffs in this case here was that the law, the prohibition on so-called assault weapons and so-called large capacity magazines, all propaganda terms as we know, is that the law allows some people to keep them, such as peace officers and qualified law enforcement officers and certain other people that were in the military, but it prevented other people from having guns, but there was no real difference between the two. And to the extent there is a difference, the legislature of Illinois made no attempt to draw that distinction when they enacted the legislation. As a consequence, Judge Webb basically said this violates the Equal Protection Clause. Specifically, he said that under the state of Illinois' Equal Protection Clause, when it implicates a fundamental right, which he said the right to keep and bear arms is obviously a fundamental right, because the U.S. Supreme Court has said so, as has apparently, implicitly at least, the Illinois Supreme Court in a prior case. He says that in that case, there's a standard of strict scrutiny that applies, which means that the government can only restrict a fundamental right, such as the right to keep and bear arms, if strict scrutiny is met. Now, you know and I know, if you've been watching this channel, when you hear the word strict scrutiny, that is terrible, 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 terrible for us, because strict scrutiny, intermediate scrutiny, tiers of scrutiny are all euphemisms for meaning they get to balance our rights away. Specifically, any kind of scrutiny, including strict scrutiny, is bad for gun rights because it allows government judges to weigh the benefits of the gun control law on the one hand in terms of advancing a state interest against our right to keep and bear arms. We in the Second Amendment community never, ever, ever want balancing test at all because it allows government judges to always balance away our rights in the name of some public good. And the U.S. Supreme Court has specifically rejected balancing tests when it comes to the federal Constitution and the Second Amendment. It says that you have to look at text, history, and tradition, and you cannot consider means and scrutiny or any sort of tiers of scrutiny. And again, Judge Webb here, because he's interpreting and applying the state of Illinois Equal Protection Clause, which requires him to apply strict scrutiny if it implicates a fundamental rights, which again, the right to keep and bear arms under Illinois law is a fundamental right, according to Judge Webb and other judges, including appellate judges in the state of Illinois. As a consequence of that, the government had the burden to show when it enacted the legislation that there was a compelling state interest to draw on these distinctions between who is banned from having the guns and the magazines and who is not. and also pointing out that these restrictions are narrowly tailored to advance that compelling state interest. Judge Webb said there's no way, no how that the government made any kind of attempt or anything that could possibly be viewed as satisfying the strict scrutiny standard, and therefore he has enjoined the law. Specifically, what Judge Webb said is, since there is no legislative history for this court to review regarding the compelling state interest or how they claim the exclusions from the act were narrowly tailored, this court, meaning Judge Webb, finds that the act fails to meet the strict scrutiny standard, and therefore he is entering an injunction, a temporary restraining order, as applied to this law. Again, another major victory for the Second Amendment's right to keep and bear arms, even though technically speaking, Judge Webb's decision here in White County, Illinois, was specifically designed and implicated through the state's Equal Protection Clause, but it has the effect of being a victory for the right to keep and bear arms. Okay, breaking news. Hope you learned a little bit something. We'll keep you informed as these things break across the country, including in the state of Illinois. We are cheering for our brothers and sisters in Illinois and our fellow Americans out there. And again, if you haven't subscribed to the Four Boxes Diner, we'd appreciate if you would do so now. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.